So the issue of concealed carry bans is once again back in the hands of the Supreme Court. This is a direct result of multiple states outright defying what the Supreme Court said in Bruen. So let's talk about what is happening. Now, real quick before we jump into the video, I want to ask you all for a huge favor. About 60% of all my viewers are not actually subscribed to the channel. So if you enjoy this type of two-way content, if you want this type of information to get out to more people, please make sure you're subscribing, and then also just double check, because YouTube loves to unsubscribe people even though they don't do it on their own. So again, just double check that. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be discussing how this issue of concealed carry and the whole Second Amendment implications is once again in front of the Supreme Court because the state of New York and other states like California are outright defying what SCOTUS said in Bruen. You may recall that recently there were 5 cases that had expedited reviews and hearings in the Second Circuit Court of Appeals because of a recent warning that the Supreme Court issued to the Second Circuit and then also to the state of New York. These 5 cases out of New York challenged New York's new Concealed Carry Improvement Act, also known as the CCIA. That New York law, the CCIA, created a hyper-restrictive concealed carry ban and essentially was a direct response to what the Supreme Court said and ruled in a 6-3 decision in New York State Rifle and Pistol Association versus Bruen. New York and the Second Circuit continued to defy what the Supreme Court said, and now you have organizations like Gun Owners America who have asked the Supreme Court to re-review this issue, to take review of the Antonyuk case, and once again strike down New York and their defiance and their restrictions on concealed carry. Now, on top of this, multiple law enforcement agencies, including those in the state of New York itself, including a big sheriff's organization in New York, are asking for the Supreme Court also to grant review to this case, and they're supporting striking down the Concealed Carry Improvement Act. Now, in Bruen, the Supreme Court struck down New York's original May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. Now, one of the primary findings of Bruen in that decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation, and that history has to date and track back to 1791. Now, another important thing that the Supreme Court said in that decision was that states like New York cannot simply just make everywhere a sensitive location. However, despite that decision, like I mentioned, the state of New York passed and rushed through the Concealed Carry Improvement Act and then passed it just 8 days after that decision. That law was challenged in multiple cases, and multiple district courts granted preliminary injunctions, which effectively halted various enforcement aspects of the CCIA. However, the state of New York appealed multiple decisions up to the Second Circuit, and they appealed the granting of those preliminary injunctions. And ultimately what the Second Circuit did is they granted stays, just blanket stays, on multiple decisions. In response to that, GOA in their Antonyuk case sought emergency review. They filed their first emergency application to the Supreme Court. The Supreme Court, on review of that emergency application, did deny relief, but that order from the Supreme Court did state that the Second Circuit cannot simply drag their feet on this issue. Instead, the Second Circuit was forced to hold expedited hearings on all these CCIA cases, which, like I mentioned, were consolidated. Recently, the Second Circuit reviewed these cases and then ultimately issued their ruling in all 5 of the cases. The Second Circuit ultimately vacated some of the district court injunctions, essentially siding with the state of New York. Now, in their decision, the Second Circuit ultimately distinguished Bruen as an exceptional case. So they said that this case here, Antonyuk and some of these others dealing with the CCIA, can't rely on Bruen really because Bruen was an exceptional case. Therefore, the Second Circuit vacated much of the district court's injunction, finding virtually all of the CCIA is in fact facially unconstitutional, so they found that it was constitutional under the Second Amendment. Again, this is the Second Circuit's decision, which is reviewing a concealed carry law that New York passed just 8 days after the Bruen decision. Now, for the Second Circuit to argue that Bruen and its rationale is distinguishable in some way from the CCIA and that it doesn't apply to the CCIA really is absurd, and that's what's being challenged. And GOA is challenging this by filing a writ assert or a petition to the Supreme Court, wanting the Supreme Court to review what the Second Circuit just said. Now, although this case is still at an interlocutory posture, this fact that this case deals directly with the Bruen decision and New York's response to Bruen just 8 days after makes it a strong candidate for Supreme Court review. Also, the fact that the Supreme Court has prior stated in this case that there is a potential for reconsideration if the Second Circuit doesn't do the right thing, if they don't handle their job, if they don't review this appropriately. That's what the Supreme Court said prior on the emergency petition, and now you have this case back up in front of them. In their petition, GOA directly points out that the Second Circuit, along with a bunch of other lower courts, continue to directly defy what the Supreme Court said in Bruen. GOA states in the petition that repeatedly the panel advanced the remarkable theory that it was not bound to apply the court's methodology in Bruen. Labeling Bruen a case of exceptional nature, the panel surmised that the courts are not required to follow Bruen's lead in cases challenging less exceptional regulations. The panel repeated this claim no fewer than 4 times, each time justifying circumvention of a portion of Bruen's framework on the theory that Bruen came out the way that it did only because it was exceptional. GOA in their brief to the Supreme Court is pointing out just how defiant these lower courts really are being when it comes to the Bruen application. The outcome of Antonyuk in this case is very important, not just for the state of New York, but other states like California. California is currently facing similar concealed carry restrictions under SB 2. CRPA filed a lawsuit against SB 2, which myself and Reno May are currently plaintiffs in. That's up for review in the Ninth Circuit. And the debate right now is what historical evidence, supports this type of restriction, if this type of restriction is proper, and the Ninth Circuit is reviewing that. And again, any outcome in Antonyuk in the Second Circuit, especially the Supreme Court grants review to this, is going to be used by the Ninth Circuit as well. And because the outcome of this Antonyuk case has broad-reaching implications, that's why multiple organizations like CRPA are filing amicus briefs. And then you also even have large law enforcement groups out of New York and California supporting GOA in their position that the Supreme Court needs to grant review to this case and then ultimately strike down the CCIA. New York State's Sheriff's Association wrote in their amicus brief to the Supreme Court that the Second Circuit stay ruling in the above caption proceeding is at odds with both Heller and Bruen's established precedents. New York State's Concealed Carry Improvement Act, passed hastily in the wake of Bruen, requires that pistol license applicants possess the requisite good moral character for licensure, an amorphous standard that seems little different from the proper cause standard that was found to be unconstitutional in Bruen. So that's what the New York Sheriff's Association said in response to what's going on with the CCIA. Now, the Peace Officers Research Association of California, also known as PORAC, wrote their brief also in support of the Supreme Court granting review to this case and striking down the CCIA. They stated in their brief that laws such as SB 2 and the CCIA encourage gun violence by constricting self-defense options and reducing the risk to criminals. This court's intervention is necessary to correct the Second Circuit's error in over-broadly defining the categories of acceptable analogs, thereby eviscerating any meaningful right to bear arms. Although purportedly intended to protect vulnerable people, these laws actually subject them to greater risk of gun violence. So it's very bad, and it's probably not going to go good for the state of New York when you have multiple groups, sheriff's associations out of New York, organizations and law enforcement organizations, highway patrol, sheriff's departments, law enforcement organizations out of California, all saying the same thing, that these concealed carry laws that were passed in response to Bruen not only are unconstitutional, but also they're going to do absolutely nothing to reduce crimes. Now, CRPA in their brief take the opportunity to walk through how the Second Circuit got the Bruen analysis completely wrong. They didn't apply it correctly in Antonyuk, and how many courts like the Second Circuit are attempting to create a new two-step approach or a new two-step test. Even after the Supreme Court recently struck down the latest one, they said a two-step approach was not appropriate when it came to Bruen in that analysis, but now in response to Bruen, suddenly you have a bunch of lower courts that are saying, no, we're going to use this new two-step approach. So you may be asking yourself, well, what does this all amount to? Well, this all amounts to a strong case for Supreme Court review. Keep in mind, like I mentioned, the CCIA was passed just 8 days after the Bruen decision. The law does things that the Supreme Court expressly said is unconstitutional, and the Second Circuit's analysis flies directly in the face of what the Supreme Court said and commanded the lower courts could not do. So right now, New York's response is currently due on May 9th. So it's going to be interesting to see how the state of New York and the government's attorney is going to address this. They're going to have to probably in some way respond to the law enforcement agencies saying that this doesn't reduce crime, that they believe also that the state of New York is violating the Second Amendment, that this is unconstitutional. So New York's going to have to respond to that, and it's going to be interesting to see how this plays out. But again, I think this is a strong candidate for Supreme Court review. Even though it's at an interlocutory posture, it deals with a prior case. The Second Circuit is directly flying in the face of what the Supreme Court said. The state of New York is directly defying what the Supreme Court said. And again, it deals with the same issue that was reviewed in Bruen. So again, shout out to GOA and all the other organizations that are jumping into this and fighting against these concealed carry laws. If we get any more information, if anything else changes, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.